My name is Jeff Morgan. I am from Dallas, Texas, and to continue on with that last video regarding Judge Dianne Hensley, I'd want to talk a little bit further about this whole idea of religious freedom. If you look at the Civil Practice and Remedies Code in Texas, Title V, Government Liability, Chapter 110, Religious Liberty, Section 110.001, Definitions, it says this. Number 1, free exercise of religion means an act or refusal to act that is substantially motivated by sincere religious belief. In determining whether an act or refusal to act is substantially motivated by sincere religious belief under this chapter, it is not necessary to determine that the act or refusal to act is motivated by a central part or central requirement of the person's sincere religious belief. Article 1, Section 6 of the Texas State Constitution actually grants all individuals the right to worship Almighty God according to the dictates of their own conscience. It protects any non-belief in Almighty God or non-adherence to religious views by keeping all individuals free from the compulsion to attend, erect, or support any place of worship or maintain any ministry against his consent. Number 3, it also restricts human authority from controlling or interfering with an individual's rights of conscience in the matter of religion. Number 4, it prescribes the giving of preferences to any religious society or mode of worship. And number 5, it imposes an affirmative duty on the legislature. It imposes affirmative duty on the legislature to pass such laws as may be necessary to protect equally every religious denomination in the peaceable enjoyment of its own mode of public worship. Now, the First Amendment of the United States Constitution says this: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The interesting thing about this law is that it's negative in its connotation. It's prohibitive. Congress shall make no law, that's a negative, and Congress shall not prohibit the free exercise of religion. The First Amendment clearly restrains government action. However, unlike its Texas counterpart, it contains no language which actually bestows religious freedom as an affirmative right. There are certain things that the government must do to protect religious rights in the state of Texas that the federal government has not given these powers to at a federal level. The United States Constitution says that Congress shall make no law respecting an establishment of religion, nor shall it make any law prohibiting the free exercise thereof. But Article 1, Section 6 of the Texas State Constitution actually goes beyond that, in that it mandates that the legislature must do certain things to protect religious liberty. So even though we have the general protection of religious liberty in the United States, in Texas we actually have further guarantees of it. Once again, to go back to Article 1, Section 6 of our Texas State Constitution, it says this: freedom of worship. All men, and by all men it also means all women, all children, all men have a natural and indefeasible right to worship Almighty God according to the dictates of their own consciences. No man shall be compelled to attend, erect, or support any place of worship or to maintain any ministry against his consent. No human authority ought, and that ought is a mandatory ought. No human authority is allowed to do this. No human authority, and that includes governmental authority. That includes the State Commission on Judicial Conduct. That includes our governor, the Attorney General. It includes our legislature. No man is allowed to, in any case whatever, to control or interfere with the rights of conscience in matters of religion, and no preference shall ever be given by law to any religious society or mode of worship. But it shall be the duty of the legislature to pass such laws as may be necessary to protect equally every religious denomination in the peaceable enjoyment of its own mode of public worship. So whereas the First Amendment of the U.S. Constitution gives the negatives, it does not mandate the positive, that the legislature must pass laws to protect the religious liberty, the religious exercise of individuals. They cannot compel the violation of the conscience of the individual, such as the State Commission of Judicial Conduct is trying to compel Justice of the Peace Dianne Hensley to perform a same-sex marriage which goes against the dictates of her religion and goes against the dictates of her conscience. Article 1, Section 6 of the Texas Constitution uses stronger words than the First Amendment to convey the breadth of the restriction on the control with interference of religious liberty. In other words, the state has no right to do this. There are some instances in which the state may, but it has to use a strict scrutiny standard, and it must go by the least restrictive means possible. So when the State Commission on Judicial Conduct is basically compelling Justice of the Peace Dianne Hensley, you must perform same-sex marriage, the State Commission on Judicial Conduct is violating, flagrantly, blatantly violating that which the Texas State Constitution mandates, that the legislature pass such laws as to protect the free exercise of religious liberty in the state of Texas. In any case whatsoever, it shall not be able to control or interfere with the rights of conscience in matters of religion. This language indicates, it shows that the people intended to claim the fullest measure of restraint over government control or interference in an individual's right of conscience in matters of religion. And if these constitutional protections are not enough, we also have a memorandum that was written by Attorney General Jeff Sessions of the United States of America from October the 6th, 2017. It was a memorandum for all executive departments and agencies, in which he says this: the President has instructed me to issue guidance interpreting religious liberty protections in federal law as appropriate. Principles of religious liberty. Religious liberty is the foundational principle of enduring importance in America, enshrined in our Constitution and other sources of federal law. As James Madison explained in his memorial and remonstrance against religious assessments, the free exercise of religion is in its nature an unalienable right, because the duty owed to one's Creator is precedent, both in order of time and a degree of obligation, to the claims of civil society. So if you are a person who believes in God, your duty first is to God. In the book of Acts, Peter said we should obey God rather than man. Our first duty is to God, both in magnitude of importance and also in order of time. Religious liberty is not merely a right to personal religious beliefs or even to worship in a sacred place. It encompasses religious observance and practice, except in the narrowest of circumstances. No one should be forced to choose between living out his or her faith and complying with the law. Therefore, to the greatest extent practicable and permitted by law, religious observance and practice should be reasonably accommodated in all government activity, including if you're a judge, a justice of the peace. It should be reasonably accommodated in all government activity, including employment, contracting, and programming. The document continues on by saying the following 20 principles should guide the administrative and agencies and executive departments in carrying out these tasks. These principles should be understood and interpreted in the light of legal analysis set forth in the appendix to this memorandum. Now, I'm not going to read the whole thing, but I will go over the 20 principles briefly that are mentioned in this memorandum for all executive departments and agencies, issued by the Office of the Attorney General, Washington, D.C., October the 6th, 2017, by the Attorney General, Jeff Sessions. Number 1, the freedom of religion is a fundamental right of paramount importance, expressly protected by federal law. Religious liberty is a fundamental right. Number 2, the free exercise of religion includes the right to act or abstain from action in accordance with one's religious beliefs. Number 3, the freedom of religion extends to all persons and organizations. Number 4, Americans do not give up their freedom of religion by participating in the marketplace, partaking of the public square, or interacting with government. These religious rights that you have as individuals supersede and are still viable when you are interacting with the government. Number 5, the government may not restrict acts or abstentions because of the beliefs they display. Number 6, the government may not target religious individuals or entities for special disabilities based on their religion. Number 7, government may not target religious individuals or entities through discriminatory enforcement of neutral, generally applicable laws. Number 8, government may not officially favor or disfavor particular religious groups. Number 9, government may not interfere with the autonomy of religious organizations. Number 10, the Religious Freedom Restoration Act of 1993 prohibits the federal government from substantially burdening any aspect of religious observance or practice unless imposition of that burden on a particular religious adherent satisfies strict scrutiny. Number 11, Religious Freedom Restoration Act protections extend not just to individuals but also to organizations, associations, and at least some for-profit corporations. Number 12, Religious Freedom Restoration Act does not permit the federal government to second-guess the reasonableness of a religious belief. This is very interesting. It does not even permit the federal government to inquire of the person, what is your religious belief? And cannot question that. And in Texas, this is strengthened even further. So that when the court might say, well, I don't like your religious belief, well, that's tough. You have no right to even question my sincerely held religious belief, nor can you compel me to violate conscience. Now, the reality is the courts do this all the time. They are acting contrary to the Religious Freedom Restoration Act. They are acting contrary to our constitutional rights. This is what the courts do. But they should be under these mandates, and especially in Texas, where we have greater protection at the state level than what we do at the federal level. Number 13, a governmental action substantially burdens an exercise of religion under the Religious Freedom Restoration Act if it bans an aspect of that adherent's religious observance or practice, compels an act inconsistent with that observance or practice, or substantially pressures the adherent to modify such observance or practice. Once again, this is a federal level thing, and as it applies to Justice of the Peace Dianne Hensley, the State Commission on Judicial Conduct is attempting to compel her to violate her sincerely held religious beliefs, which, by the way, do accord with the religious doctrine, and also to violate her conscience. And yet this document says at a federal level, this is completely impermissible, and once again, at a state level, it is even more impermissible because the state of Texas actually, at least in theory, has strengthened guidelines to protect the religious liberties of individuals than what we find even at the federal level. Number 14, the strict scrutiny standard applicable to the Religious Freedom Restoration Act is exceptionally demanding. So what it goes on to comment is this: once a religious adherent has identified a substantial burden on his or her religious belief, the federal government can impose that burden on the adherent only if it is the least restrictive means of achieving a compelling government interest. So in the case of Justice Dianne Hensley, she said she would not do so for purposes of religious conviction, and so that she would not be violating her conscience, and yet she also provided a list of names of people who would perform same-sex marriage. The State Commission on Judicial Conduct, that body who claims authority but from the Texas State Constitution and yet ignores the Texas State Constitution, is trying to compel her to do that which would violate her conscience. This goes strictly against the whole idea of strict scrutiny, and that they must provide the least restrictive means of achieving a compelling government interest. And by the way, what is the government interest in same-sex marriage? Our Texas State Constitution defines a marriage in Article 1, Section 32 as only between a man and a woman. In the state of Texas, our Constitution says there is no same-sex marriage even permitted. Furthermore, there shall be no other institutions created identical to or similar to marriage that would allow this. So here is the State Commission on Judicial Conduct making up its own laws, making up its own rules, making up its own constitution by which to govern and to rebuke a judge and force her to violate her conscience. This entire State Commission on Judicial Conduct team, including Chairman David Hall, should resign immediately. And if they don't resign immediately, Governor Greg Abbott should force their resignation immediately. What they did was tyrannical. It goes against every single aspect of our Texas State Constitution. It goes against every single aspect of justice. Number 15, the Religious Freedom Restoration Act applies even where a religious adherent seeks an exemption from a legal obligation requiring the adherent to confer benefits on third parties. Number 16, Title VII of the Civil Rights Act of 1964, as amended, prohibits covered employers from discriminating against individuals on the basis of their religion. Number 17. Title VII's protection extends to discrimination on the basis of religious observance or practice as well as belief. So some people want to say, well, that's okay what you believe. But no, going back to 1964, Title VII protection says that we cannot discriminate on the basis of religious observance or practice. It's not just your sincerely held religious beliefs. Your beliefs are allowed to influence your behavior and your practice. You cannot discriminate on that basis unless the employer cannot reasonably accommodate such observance or practice without undue hardship on the business. Now, in the case of Justice Dianne Hensley, she provided a whole list of other officials who would perform same-sex marriages. How is this burdening these people? How is it that she is not providing some type of means, some type of accommodation for them so that she can maintain her conscience and so that she can keep her conscience intact and yet allow these people to exercise a marriage which again violates the Texas state constitution? I do not understand this. The State Commission on Judicial Conduct needs to resign immediately because of their flagrant abuse of power. Number 18, the Clinton guidelines on religious exercise and religious expression in the federal workplace provide useful examples for private employers of reasonable accommodations for religious observance and practice in the workplace. One of the things that I'd like to point out here is that the Religious Freedom Restoration Act, this is not just some right-wing conspiracy that's being signed and the right wing is forcing its religious agenda on society. If you go back to 1964, it was under President Lyndon Baines Johnson, a Democrat, that was passed. Of course, with the help of the Republicans, because apart from them, it would not have passed. And when you look at the Religious Freedom Restoration Act, that was signed by Democratic President Bill Clinton. So I would not say that either of these people were extremely right-wing, and this is just some type of a right-wing agenda that they're forcing their religion upon us. Two Democratic presidents, Lyndon Baines Johnson and William Jefferson Clinton, signed these into law. Number 19, religious employers are entitled to employ only persons whose belief and conduct are consistent with the employer's religious precepts. Once again, this is coming from the Office of the Attorney General of the United States. This is a memo for all executive department and agencies on what the existing guidance is regarding religious discrimination in the workplace. And finally, number 20, as a general matter, the federal government may not condition receipt of a federal grant or contract on the effective relinquishment of a religious organization's hiring exemptions or attributes of its religious characters. So even the federal government cannot discriminate against a religious organization applying for some type of a grant or contract or whatever it may be because it's religious. A religious organization does not have to become secular, and Judge Dianne Hensley does not have to forego her religious convictions and violate her conscience in order to remain justice of the peace. The State Commission on Judicial Conduct has abused their power. They have abused their authority. Every single one of these members, starting from Chairman David Hall on down, should resign immediately, and if they don't, Governor Greg Abbott of the state of Texas should force their resignation. I support Justice of the Peace Dianne Hensley in her lawsuit against the state. I hope she wins. This is a very crucial lawsuit for people of Texas. This is a lawsuit which will determine whether your religious liberties will be, not just should be, because they should be by our Texas state constitution, but whether the government will actually obey and put itself subservient to our Texas state constitution. Religious liberty is a right that is protected in the state of Texas. It is given greater protections in the state of Texas than it is at a federal level. I support Justice of the Peace Dianne Hensley in her lawsuit. I hope she wins, and I hope she wins big, not just for the sake of winning big and pushing back the agenda of the sexual agenda of the LGBTQ community, but because this is a matter of supreme importance to every person whose faith is important to them, that they are allowed the free exercise of their faith, the observance of their faith in the public square. And if you are a public servant, you are allowed to have your faith impact your work. Thank you.